Hold on, I think.
Hello, it's Friday, June the 20th, and we are here today to talk about messy divorces. And we are joined by Ari Wormelli. Did I pronounce it right, Ari?
That's right.
Okay, excellent. Who is a family law lawyer and a mediator. And one cute thing that I read on Ari's website is that he comes from a theater background, which reminds me of the last episode we had with Raj, where like a lot of Shakespeare was spoken. Mm-hmm. And so, anyways, I think we should just dive right in to talk about messy divorces. I think it's something.
So what you're saying is once more into the breach, once
yes,
more.
Yes, exactly.
Only one I know. Out, damn spot, out. But yeah, this comes. So Ari is as Deanna was saying, is it family lawyer or divorce lawyer? What do you call yourself?
Family lawyer.
Family lawyer.
We do. I mean, for starters, you only get divorced if you're married, and we certainly deal with people who aren't married. And we also deal, of course, with cohabitation agreements, prenups, marriage agreements, whatever you call them. It's more or less the same thing. There are also people at the firm who do things like adoption and so on and so forth. So it's and surrogacy agreements. So it can sort of run the gamut a bit.
And so, I've gone to Ari before to get expert opinions on certain matters pertaining to immigration law, and issues of divorce often come up. And we have some questions that primarily consultants, I think, were asking, because obviously people who immigrate to Canada may have spouses overseas. But before we get into some of the specific questions, maybe can you just walk us through, like, how does one get divorced in Canada?
I mean, good news is divorce is easy. Divorce is never the problem. It's all the other issues, parenting time, child support, spousal support, property division. Those are usually the problems. It's rare that divorce is an issue. And, in Canada, it takes two people to stay together and only one to divorce. And when somebody wants to divorce, it's hard to oppose it. You may need to bring it into an application if somebody's opposing it, but there's a very narrow set of circumstances where an actual divorce would not be granted. That's usually when adequate arrangements, meaning financial arrangements, have not been made for the children. So there's no or possibly inadequate child support in place, and that can run a bit of a gamut. Do you have an order? Is it an interim order, etc.? If somebody is refusing to remove a religious barrier to remarriage, like if you're not giving, for example, for Jewish people, the man has to give a woman a get. And if the man, in order for her to religiously remarry, and if the man is not doing that, then, he's going to have some trouble getting a divorce from the courts in Canada. Also, if you're in breach of a court order, just like any relief that you're seeking from the court, you're going to have trouble. And then the fourth is where the divorce might affect a property claim. If you've got, say, a foreign property claim that's going to be negatively impacted by the divorce, and you've got some expert evidence with respect to that, the court may decline it. But other than that, those are really the only reasons that a court should be refusing a divorce. And the only criteria is that you've been separated for a year. There are some ways where that timeline might be shortened, but generally speaking, you have to wait 1 year from the date of separation. And after that, you can get divorced. So divorce itself, not that hard, fairly simple.
So I think the question that arises most often, and the one that I often have like contacted you about, is there's someone in Canada trying to marry or immigrate, both in some situations, and there's a spouse overseas.
Mhm.
How would divorce work in that situation? Let's discuss both scenarios where both parties say, you know what, yeah, we'll separate. But what if the other party that's overseas is saying, you know what, I don't want to, or I want cash, or something like that? The reason this arises is that in the immigration context, even if a person overseas isn't going to be part of the immigration application, if the immigrant and the non-accompanying spouse are married, the non-accompanying spouse overseas still has to do forms, still has to do a medical exam, still has to do
Yeah,
police background checks. And
yeah,
often they may
they're
say,
not going to do
I
that.
don't want to.
Yeah, yeah,
And so then the person here is saying, well, we're never going to live together again. I
yeah.
want to divorce this person. So let's go through both scenarios. One where the person says, I agree, I'll get divorced. And the other where they're saying, you know what? No.
I mean, in either case, what might end up being the primary practical barrier or issue is there. In order to start a divorce action, you have to have been resident in one province for a year before then. So, if you're resident in Alberta for 6 months and then you move to BC, well, the clock restarts, right? And as a matter of practicality, that's probably your biggest issue. But certainly, if you don't have children and you've been resident in a province for a year, um, then the fact that the other person doesn't want to get divorced is not really going to be a barrier. Um,
Does it complicate or slow things down? Do they have to be served?
they do have to be served, and but it's not usually that complicated. Um, I mean, you can have them personally served, and yeah, sometimes that's a bit of a pain. If for some reason personal service is difficult, um, I'm echoing back to not the current, Ukraine war, but 2014, I want to say, when Crimea was occupied. We had an opposing party who was in and around that region, and so I had to go in and get an order for what's called substitutional service because we had a live email address and we didn't really know where she was. And yeah, I mean, process service in a war zone is expensive, hazard pay. And is it really, is it practicable is the test. And, the court agreed with me that, yeah, maybe not so much. And so I got my order for substitutional service and that's how we did it.
What
So
changes if there's kids?
Sorry?
What changes if there's kids?
Well, if there's kids, then that gets back to the issue of have adequate arrangements, meaning financial arrangements, been made for the child, right? So, I mean, if the child's here in Canada and resident with the person applying for the divorce, that's probably going to be a navigable issue. But if they're still back wherever, then, one might look at what do we consider adequate arrangements to be for the child.
Yeah.
One solution there might be to just pay what the Canadian table says you should pay on your income, and depending upon where the child is, that might be more than sufficient. Depending upon the way that they've structured their child support, you might be overpaying, but if you really want a divorce, that might be worth it for you. On the other hand, looking at the domestic regime of wherever the child is, you may need to comply with that. And it's conceivable that you might get, I'm not aware of any case law that's directly on point, but though there probably is, but I could readily see that, yeah, you might need some kind of regime in place that corresponds with the country where the child is, and whether that's in the form of a court order from that country or some kind of equivalent of a separation agreement, I don't know, but I could see you needing something, and you might need some expert evidence possibly to say that whatever you're doing is in compliance with the local regime. I don't know.
That makes sense.
But I could see that becoming a potential barrier, and that might even require lawyers in 2 jurisdictions.
Yeah.
Does any of this change if the spouse overseas lives in a country that doesn't have divorce? And I'm thinking specifically the Philippines. Deanna's smiling and nodding because she has a big caregiver practice, and this issue probably most frequently arises with Filipinos.
Yeah. I mean, and they might not have divorce there, right? But I mean, for example, in Canada, we have the Divorce Act, and that has provisions in it for child support. But we also have the Family Law Act in BC, which is provincial legislation, and you can get a child support order under that, even if, you know, you're not married, or alternatively you are married, but for whatever reason you're not seeking a divorce at this time, who knows? And my assumption is that while the Philippines may not entertain divorce, they probably have some way of making sure that children receive money from both their parents, even in the event that the parents are on the outs and not living together. That's my guess. And, you know, some of that is simple economics, right? If they're not being looked after by their parents, then maybe the state has to look after them, and the state doesn't want to shell out for that. So my assumption is there probably is a child support regime in the Philippines. And so, again, you know, you would want to get some order or something in the Philippines saying, hey, you know, we've complied with the local requirement for child support there, and once you've done that, you can get a divorce in Canada.
I think there'd be a lot of interest in seeing that. I mean, at the beginning of my practice 20 years ago, I used to do desk ordered divorces for my Filipino clients. And it was, I mean, the first obstacle to overcome was telling people that they could get a divorce in Canada, because a lot of people just had it in their mind that because they're from the Philippines, divorce was just never going to be available to them when they married in the Philippines. And so that was the first issue. But I started to encounter that when proceeding with the Canadian divorce in British Columbia, there was this whole process when there were kids involved of much more complicated, you know, having to put in all of those documents to establish, you know, and it became much more structured and much more difficult. And that's when I stopped doing them all together and started referring them. I was in the not-for-profit sector at the time. And I was like, I'm sorry, we can't do it for you. You need to get
what I will say is it's good for you. You know, there's some rumblings about people who want to be able to do simple divorces. And my thought is, unless you have some idea of what a complicated one is, and when you're in those waters, it's hard to tell when something is simple or maybe it's got, you know, the potential to become unsimple, you know, rapidly. I will actually add one sort of caveat and clarification to what I've said. Interestingly, you know, for a while, same-sex marriage wasn't legal in the US, but it was in Canada. And so you would have same-sex marriage tourism, effectively. People would come up here and they'd get hitched, and then they'd go back down to the States, and the States would recognize, you know, the foreign marriage for the most part. But the problem was that even though the state would recognize the foreign marriage, the state would not allow for, you know, divorce between two homosexual people, right?
Yeah, totally.
And so Canada brought in special legislation to allow people who had been married in Canada and whose home state or country did not recognize well, homosexual divorce. They were fine with the people staying married, but they couldn't get divorced. It's a little bit of an odd odd conundrum when you think about the political genesis of that, but
Yeah.
that was the situation. These gay and lesbian people had to be married, had to stay married, but you would pay some money, and even though you were non-resident up here, you could go get a divorce. And so I will say that there is potentially, even if you haven't been resident for a year, if you're gay and the other country doesn't recognize the divorce, and you are married in Canada, you may have an alternate avenue, even though you don't meet those normal residency requirements.
For sure. Well, this really dovetails well with this messy divorce thing, because even if it seems like a simple divorce in your own like desk order, there was no children, it can get very messy because of the conflict of laws issues that you've referred to. Because like, it's sort of like the email that we exchanged before this session, is that like, you might be now divorced for Canadian purposes, but if you then go back to the Philippines won't recognize your Canadian divorce in certain circumstances. So there is often situations where, yes, you're divorced by Canadian standards, but not by the laws of the Philippines. So I think you should never be getting a divorce, in my view, without getting legal advice from somebody who really understands family law.
Oh yeah, but I think understanding that it's an option is super key. Like whenever I was speaking with someone, which sort of is what gave birth to this podcast topic, although we may have discussed doing it before. But in order to get that annulment in the Philippines, one of them is that one of the parties has to essentially have become a psychopath, which was defined as like
legally incapacitated.
Incapacitated, and to be so the person was like, will there be any Canadian immigration consequences if I sign this document which says that I lost my mind and that I was abusive in order to get this annulment? Because
even then it will take probably 3 years,
Yeah. And I went, well, what about just a divorce? And they said, well, is that an option? So, I mean, we've discussed this a bit, but just in brief, it is an option, right? Like they should contact a family lawyer, because if they have lived in whatever province for more than a year, it could be a straightforward process, especially compared to divorce in, I don't know, I find the Philippines and Pakistan are the two.
Yeah, but as an add-on to that, if you then try and go back to the Philippines and remarry a second spouse, Canada, for immigration purposes, may not accept that as being a valid marriage. So it is very nuanced, and I think that if you're trying to do that, it is indeed possible, but I think you need to make sure you're getting advice from a sophisticated immigration lawyer and a very sophisticated family lawyer, as well as a lawyer in the country where you might wish to remarry. So it's totally possible, but I think you need like 3 very experienced and knowledgeable lawyers. It's like
the issue there that I can see is that if it's not if you're getting married in the Philippines, and I say getting married in quotes, but it's not a valid marriage in the Philippines, in the place where you're getting married, then Canada might well say, that's not a real marriage as far as we're concerned, because it was, in the country where it was done, it wouldn't be recognized as valid.
100%. But the problem is, if you just carry on with your immigration process and convince that first spouse to go through an immigration examination, if they come up as medically inadmissible, you would also be found inadmissible, and you might be denied your Canadian immigration status. So it is really complicated. It's not like, well, I'll just do this, because then it's hard to try and say, well, actually we're separated, because then that could be found to be a misrepresentation. Like, it's quite a ball of wax.
Or the other one that arises is if you're married, and I've seen this with Filipinos, where they are married to someone who's been married twice, and then they become inadmissible because their non-accompanying partner is inadmissible for bigamy.
It's wacky. And also, like, there are marriages in the Philippines that are that are conducted under, like, I can't remember what article it's called, article something or other. And that means they've sworn an affidavit that says that they lived common law for a year prior to their marriage, and that makes them inadmissible for perjury. So, which is serious criminality. There's like, again, there's all sorts of things you need to understand about the family law and what the immigration in the country of origin and what the potential criminal consequences are for immigration purposes. It's like, it's wacky.
Yeah. You know, I mean, anytime you say, hey, I assaulted this person, right, you open yourself up to civil liability. And at that point, you know, the person doesn't have to prove, at least in the common law world, you know, the trespass torts, the person no longer has to prove that the action occurred, and it just becomes a question of damages.
Yeah, well, in immigration, it's reasonableness standard. So someone can be inadmissible to Canada if it's reasonable to believe that they committed a crime overseas. So let's get in. For those who are watching on YouTube and were wondering why I used that format to show the questions, it's because the next question is a bit of a whoops, I put the wrong one, is a bit of a novel. And so I'm just going to read it, and then we're going to get to the questions. So this is the fact pattern, so to speak, which is there's a Canadian sponsor who gets divorced in Pakistan after receiving a divorce judgment in Pakistan, and they get married to someone else. This question comes from an immigration consultant. That person comes back to Canada. His ex-wife from the first marriage insists that they also file for divorce in Canada. So she files for divorce in Canada, and the Canadian divorce is issued, but the date on the Canadian divorce judgment is after the second marriage date. So this person eventually applies to sponsor his new wife, and he submits both Canadian and Pakistani divorce documents. The sponsorship application is refused by immigration authorities because the second marriage took place before the date of divorce in Canada. This person didn't appeal or reapply. They have a child. It's been 10 years and his wife is still in Pakistan. He wants to apply for a TRV or visitor visa for his wife. So that's the fact pattern. You can tell this is real because there's no hypothetical like based on this. You can tell that this is a real situation. So the question, then the consultant has multiple questions. So the first, recognizing foreign divorces. They're asking, is there a formal application that one makes to get a foreign divorce recognized? Is it necessary to get the divorce in Canada? When does Canada recognize foreign divorces?
Excellent question.
Generally, Canada is fairly liberal in terms of recognizing foreign divorces. It's and to some extent, it's sort of codified in, I think it's Section 22 of the Divorce Act, which also preserves the ability to recognize divorces at common law. One of the particular issues that, you know, kind of, I mean, my first thought is, well, okay, if the divorce in Pakistan was a recognizable divorce, then use that one. And essentially, the divorce in Canada is, you could look at that as a nullity or moot or whatever. But in any event, you know, these people were already divorced as at the date of the Pakistani divorce. The one little possible factual hitch there is that and there, I don't think there are any cases in BC that address this directly, but there's a line of Ontario cases that have been picked up by the IRB, I think, the Immigration and Refugee Board, that talk about, well, there has to be some kind of formal state function in terms of pronouncing the divorce, some kind of state oversight. So there are some some divorces that are referred to as talaq divorces, where basically somebody just says, and this is my understanding of it, and I could be very, very wrong, but they just basically say talaq a couple of times, and
Right.
And then they're officially divorced, and then they go, well, not officially divorced, but then they go somewhere else and they just say, hey, I've done this, and they register the fact that they've done this, and they get a little certificate that says that. Well, that's not considered sufficient for our purposes, because all that is a recording of the fact that somebody's done X. It's not there's no formal state function involved in the process of the divorce. And so where that has happened, the IRB has picked up on those Ontario cases and basically said, yeah, we don't recognize the divorce. And in that case, they're left with the Canadian divorce, which is problematic. But I mean, the short answer to that first question is no, you don't really need to do anything special to have your divorce recognized in Canada, 98% of the time. You have your foreign paperwork, and that should be accepted by, pretty much everywhere, including immigration authorities. But the paperwork has to indicate some kind of formal state oversight in the process to some extent.
Ari, you've reminded me very much of a case that I argued many, many, many years ago at the board, where it was a similar type of a marriage arrangement. It was not in Pakistan, it was actually in the Philippines again, but it was a Muslim marriage, and it was also something equivalent to like I don't know if it was actually a talaq style divorce, but it was one where it was done verbally by the husband, where like an oral, I divorce you, but then they again had intercourse, and that was considered a nullification of the talaq divorce. So it was again like the board considered the divorce annulled. But it was like, it's something like it's very factually dependent whether or not it was effective by the state in the Philippines under, I guess, Sharia law as it was being administered in the Philippines. I don't think it came down to the state recognition, but ultimately, I think in this type of a scenario, my instinct would have been that when the initial refusal came down, I potentially would have looked at the facts of whether or not that decision was wrong. And if it was arguably wrong, I would have applied for judicial review. And, so something like that. And if that wasn't tenable, then I would have gotten a family law opinion and, put in an expert affidavit from a family law lawyer and said, from Canada, and said, in fact, this divorce, yes, exactly, I'm sure. And then, but now that you are where you are, then I think you just need to get an expert opinion from both the foreign jurisdictions. And in my case, I adduced an expert witness from, like a Sharia witness from the Philippines saying, no, in fact, they were divorced. Here's why I think that.
Yeah, I mean, when I've dealt with talaq, and I'm just looking, I pulled open a client's talaq divorce, and as Ari said, it literally just, I hereby divorce this person by pronouncing upon her talaq, and discontinuing all connections. And so what we did there was the client was able to go to Pakistani authorities and get a government recognition almost backdated. Is it possible to have a divorce judgment in Canada backdated?
Not really, no. I mean, it's effective when it's pronounced, it's pronounced, and then normally there's a 30 or 31 day waiting period until it takes effect, and that's because undoing a divorce once it takes effect is somewhat legally challenging in terms of the notion. So they have that 31 day period for the appeal period, right? So that you can, you've got that opportunity to do a stay of the judgment. But yeah, you can't really, you can't really backdate it, because the date of the divorce is the date of the divorce. The date of separation, is and generally should be speaking, at least a year prior to the issuance of the divorce judgment. In I'm going to say 90% of circumstances, but yeah, you can't really backdate
Yeah, it makes sense.
that. And yeah, if the divorce is, if there is some kind of state function and the divorce is legal, and a legal thing in the country where it was issued, then you're fine. Deanna, I mean, the issue in your case would have been that issue of, well, was it rendered a nullity in the jurisdiction in which it was issued by virtue of the fact that these people just decided to have one last hurrah.
Exactly.
Yeah.
I mean, the issue in that case was actually about whether or not she was in a bigamous marriage. So it was a totally different question. But again, in answer to this particular question, I think we don't have enough facts to suggest what this person would do. But I wouldn't put aside, like from an immigration perspective, but I just wouldn't put aside entirely the possibility of pursuing the judicial review with a motion for extension of time. Like if they reasonably believe that again, it's very, very fact dependent. Personally, from an immigration perspective, I would need to know a lot more about whether or not it was actually a valid divorce in Pakistan and why they didn't proceed with a judicial review or an appeal at that time to be able to give an opinion as to whether or not they should still pursue a federal court proceeding, or whether or not they could apply again for a sponsorship and see if they could just explain why, in fact, the first decision was wrong and why they should be allowed to reapply. So again, it's just not enough information for me. I don't know if you feel.
Well, and their second question at the bottom is, should they just divorce everyone again and remarry?
Exactly.
Yeah. And those are really my two thoughts. Is one is look at whether this falls into the line of I'm going to refer to it as unrecognized talaq cases, or is it a divorce that is capable of and should have been recognized, by the immigration authorities, in which case challenge it on that basis and say, you know what, forget about the Canadian one. Let's focus on this one because it was valid, and you can't ignore a valid divorce, right?
Yeah.
You know that there's a valid divorce. You can't be going around saying I'm still married, right?
Or can they just remarry? Like if they are divorced in Pakistan, couldn't they now?
So Deanna, in that situation, would you be worried about either divorce or marriage of convenience in the immigration context?
Not really. I mean, it's like it's the same person, because divorce of convenience is about divorcing a person with the intention of remarrying a different person. And I don't think that that's the issue here. They're trying to.
I wonder if that's been litigated.
I'm sure it has, or even if it hasn't, I think I've certainly had it argued in the opposite case where they said I've had divorce of a convenience allegations made. I'm just trying to remember what they were exactly, where they said that somebody had divorced of convenience when in fact. Anyways, I've had divorce of convenience allegations in numerous contexts when I was able to defeat it.
Yeah,
so
basically under Canadian immigration law, marriage isn't recognized if it's done for, well, if the marriage itself, the relationship isn't genuine, or if the primary purpose is immigration. But I mean, these recognition of like foreign divorces, even I remember, gosh, it's probably now coming up almost a decade. And maybe I've talked about this on the podcast. There's a case Ari helped with where we had a marriage application in for someone who had gotten married under a different name using stolen identity. We did an Access to Information Act request. This was back when the files were paper. And Deanna, you'd love this. We got the email of or the CD of the application. And this was the case where there was a Post-it note on
CD, because we can all see CDs now.
Yeah,
right?
well, but on the file there was, so they had to scan the physical file, and there was a Post-it note on the IMM 008 which said, "Do not disclose. We have concerns about whether this marriage is real," but they had forgotten to take the Post-it note when they were processing the ATIP.
You told me about this.
I had to go to Ari for an opinion on whether a marriage will be recognized in
That's
British
who Ari
Columbia.
is.
Yeah, exactly. This is Ari.
I've heard this
And
story before.
if it was under a fake ID, and maybe Ari, you can give the opinion, is that are marriages where somebody is married under a fake ID recognized?
Yeah.
Oh wow! Oh, cool. That's not what I would have expected. I thought it would have been point of
No,
an
and
issue.
it wasn't what IRCC expected either.
Oh, yes. That's cool. I love those.
I mean, the issue is really the issue there, at least in Canada, right? And again, if you want the marriage recognized in Canada, it has to be legal in the jurisdiction where it was performed. But at least in Canada, it's really about, do you know who you're getting married to, right?
Right.
And and as long as, and so the fact that it may be a different name, I mean, I suppose arguably, if somebody thought that they were getting married to Elon Musk, and it turned out, maybe that might be, but generally speaking, the name is not the main issue, and there's a strong presumption of validity.
Right.
And for marriage in Canada, we look for reasons to uphold the validity of a marriage in Canada, as opposed for reasons to undo it. Before we totally get away from that last question, I did want to say that, I mean, yeah, the other option is that, hey, if it turns out that divorce number one really wasn't valid, right? And so therefore, divorce number two in Canada was the operating divorce. So therefore, my marriage was invalid. You could go to court, seek a declaration of invalidity with respect to the marriage, because you were not in a position where you had, the capacity to marry. We usually talk about that in psychological terms, but
is that the same as annulment?
And then get remarried.
Is a declaration that the marriage is invalid the same as an annulment?
Yeah, I mean, functionally,
it's like a declaration of nullity, right?
It's a different, I mean, it's a different kind of thing. Like normally when you talk about annulments, you're looking at some kind of invincible averment to the act of consummation or something like that. And that has, in BC at any rate, that has a little bit of flex to it. There was an interesting case a few years ago where people had gotten civilly married, but not religiously married yet, and they were holding off on having, or maybe it was the opposite, I can't remember, but in any event, they were holding off on having sex until the last one had been achieved, right? And so the court basically said that, okay, that decision that you guys were not going to have sex, and that the idea of having sex was not something you guys were on board with until, this criteria happened, that was sufficient to qualify such that, we'll give you an annulment.
Right.
And that's a more modern interpretation, I would say. 10 years ago, I probably wouldn't have pictured that result, but here we are.
But honestly, in the current climate, it wouldn't surprise me if an IRCC officer said to somebody, "Have you consummated the marriage yet?" And if they had not, starts arguing that the marriage wasn't legally valid. Like, we're in that kind of an environment right now.
Well, and I would question that.
What?
Because it's
come on. Well, maybe at the IRB.
Honestly,
maybe at the I could see CBSA asking that.
100%.
But maybe.
Honestly, like the way that I'm seeing all these spousal cases come up for rejection and the kind of stuff that I'm seeing before the board, it's pretty wacko. So this is one of those cases, Steve, I believe you'll be like, Deanna, you're crazy.
But we've asked the other way, so if somebody didn't declare that they were in a common law partnership at the time that they immigrated to Canada, they can't in the future sponsor that person. And so in determining whether someone was common law or not, we'll often examine into that. Like, had they had sex before they got married? Some people will say, no, we waited until we were married to have sex.
What a
We would
great
never
idea.
have sex before then.
That's
Yeah.
And
brilliant.
that actually seems very like persuasive.
Of course it is.
Yeah.
Of course it is. Yeah.
I mean, although I will say that, you know, I mean, depending upon what definition you use of a common law, you know, relationship. I mean, in BC, you know, we use the term marriage-like relationship, and there's a whole bunch of criteria. And the mere fact that you haven't had sex, yeah, that's one of the criteria, but it is entirely possible to be in a marriage-like relationship without sexual intercourse.
Lots of people are.
And, well, no, but I mean, you know, you have people in the, you know, they're asexual or whatnot, and you know, from their perspective, I don't really see any reason why just because they haven't had sex, their relationship shouldn't be recognized and, you know, afforded some respect in the protection.
For sure. But isn't it about intentionality? Like if you haven't had sex because that's for you something that you would leave to a point where you have reached that certain level of commitment.
Yeah, I mean that is an element. You might look at other issues to see about that intentionality. Like, do you guys have joint bank accounts? You know, are you, you know, paying for the all of the other person's housing bills? You know, if somebody broke their leg, did the other person take time off work, you know, to go, you look at the context and go, does this look marriage-like? And
it's very confusing because you have to like pinpoint it almost, because the presumption from immigration officials will be once you were in a relationship and living together for a year, you were common law.
Whether you like it or not.
Whether you like it or not. But as you're saying, that isn't actually the test.
And it might not be. I mean, you know, people can be, and I tell clients this all the time, you know, just because somebody goes off to France and, you know, they study for a couple of years and then come back doesn't mean that you guys are separated. Likewise, you know, you guys can be living in the same house and continuing to do that, and you guys can be separated, right? And as a matter of fact, I would say that that's more common than not, where people are separated and there's a period of time where they are continuing to, you know, live together in the same piece of real estate.
Especially in how expensive.
Well, exactly. Tangle your lives, and
or it gets complicated where there's like 6 people living in a house. And the couple's one of them. Deanna, you had this question. I don't know if you want to tee it up.
Oh, this is just, again, really what I'm trying to get at here is that, like, it's sort of similar to the Pakistan question in the sense that there are a lot of cases that I've had where a person is married in the Philippines. And so in the Philippines, they're considered legally married. And then one of the spouses comes to Canada and they divorce because they don't want to be in that relationship anymore. And so they carry out a Canadian divorce, but then they have another person in the Philippines. They go back and they then marry that second spouse who is also a Filipino. And Canada does not consider, the Philippines does not consider that second marriage legally valid. And so when they come back to Canada to sponsor the second spouse, Canada does not consider that spouse legally married, but the second spouse can't come to Canada to get married because they can't get a visa. And so, like, you know, what do they do then? How do they, and the Canadian the Canadian spouse who's born in the Philippines doesn't want to go back and live with them for a year because they have a job here. They are settled here. So what do they do?
I guess at that point, if they can't enter Canada at all, you know, they can't even, you know, come for like a weekend. Then I might look at other jurisdictions, like, you know, could they both, and I understand, so maybe they don't want to give this person a visa even for a weekend because they're worried, you know, the person that they're in a relationship is, the person that they're in a relationship with is in Canada. Maybe they're going to overstay their welcome.
Exactly. Or they know that they're going to get married and then do a sponsorship. And so, you know, they don't want to facilitate.
I mean, I would be disappointed if that last for the reason. That seems to me to be
Oh.
not the way people
Welcome to our world.
yeah, right. It's not in the spirit of the legislation that we have regarding marriage, which is we try and make it valid. But in any event, like Las Vegas, nobody lives in the U.S., so maybe the U.S. isn't going to have those same concerns about overstaying the welcome, and maybe they could both have a weekend in Vegas and get hitched there.
Yeah.
In Canada, that marriage in Vegas would be recognized.
The reality is it's very hard for Filipinos to get visas to any like Western jurisdiction. This is what the fundamental problem is. So like maybe in Thailand, they could get married. You know, but it's like, that's, exactly. I was just wondering really with all of this, is there anything from a family law perspective in Canada they could do to remedy the not validity of their Canadian?
Yeah. I mean, the only thing that I could think of, and because I have no idea really how immigration law works, but because they're not married doesn't mean that they're not, in a common law relationship. I don't know if that counts for anything.
Have to have that period of cohabitation for
okay.
Exactly.
They haven't had that. Okay. Okay. I mean, and here's another thought is, when they use the word cohabit in the immigration context, is that defined? Because when I hear the word cohabitation, again, it doesn't require, like there are cases where one person lives in Canada, just on this side of the border, and the other person lives in Washington State.
No, so you're allowed like short gaps for work and stuff.
Yeah.
But if a family's traveling, you literally wind up having to be like, we were 1 month in this jurisdiction, here's our Airbnb, and then we went together here. Like there really is.
You have to
an emphasis on being physically together.
Yeah. Okay. So that might not work. Yeah. They'd have to find, and because it's not legal in the Philippines. Canada won't recognize a marriage that's invalid in the jurisdiction that it's been performed. So they're going to be stuck with having to find a third safe harbor. If they can find someplace, I mean, I used Las Vegas, right? Because lots of people, it's easy to get married there.
Exactly. It's the marriage capital.
But if they can't do Las Vegas, if they can get legally married in Thailand, or heck, Saudi Arabia, like
exactly
a Western country.
Totally.
I just use that because I know for a fact that any marriage that's legally performed in Las Vegas is going to be, legal in Canada. I don't see offhand why a marriage that is legally valid in Thailand, wouldn't be legally valid in Canada. I know I've seen marriages performed in Saudi Arabia that are legal in Canada.
The idea of destination
Saudi Arabia, but if just one, you're fine.
We just got a question. Can someone get married in British Columbia if they don't have status here, if they're here illegally?
I don't see why not.
Have you heard of marriage commissioners reporting anyone to CBSA or?
I mean, I haven't, but that doesn't mean it doesn't happen. I mean, but
I've definitely had clients who are without status get married in Canada. And do a sponsorship without incident.
But I mean, there's no reason, like once they're there, like the immigration status and the legality of their presence on Canadian soil is not an element of the things that are necessary to have in order to have a marriage. So I see zero reason.
I hope we just haven't tipped off the department for a new enforcement area, but
contacting commissioners. I think that commissioner would be out of business very quick.
As one of my colleagues likes to say, a lot of people have the attitude of not my monkus, not my circus, and
I have no idea what that
not my circus, not my monkey.
Bingo, right?
Okay.
Yeah. And so
good on them,
for the most part, these people aren't interested in doing a whole background check and as from Indiana
love is love.
paper chase,
Yeah,
Yeah.
totally.
I've never seen a marriage commissioner ask for somebody.
No, we had one where they knew that the person was out of status, and they
Yeah.
ran into our office with not the certificate, but like whatever the attestation is that they do at the marriage.
Exactly.
Yeah.
Don't ask, don't tell.
Back when the 60-day deferral period was like
Exactly.
valuable.
Yeah.
Which
Exactly.
is not as much anymore.
But to me, the lesson here is that clients need to be wary of divorcing and then go, if they're from a jurisdiction where like there are definite limitations on validity of marriage and divorce, they need to get advice before they just run back after getting a Canadian divorce and getting married. And family law lawyers need to be, when they're asked questions about can I get a divorce in Canada and then go back, that they also need to be wary of consulting with an immigration lawyer. And Canadian immigration lawyers need to be very, very careful of always getting advice again, like all this.
Well, I think the bigger one and like the big takeaway and sort of the point of the episode, someone else just commented on YouTube, "Love is wicked." Is that another quote you hear a lot, or?
Sorry?
Love is wicked?
I haven't heard that one, but yeah, it can be for sure.
But again, the big one is like the amount of times when that overseas spouse, where a marriage has for all intents and purposes broken down and they're separated, is holding up an entire family's immigration, to know that like you don't have to do the divorce in that jurisdiction where that person may be demanding money, where the system may be corrupt, or it may not even be possible if it's the Philippines, and that divorce here is an option. And that it's worth speaking with someone. Because again, what's the timeline that it could, what's the fastest that it could happen?
I mean, if you have been resident in a province for a year, could happen. If you can prove adultery or cruelty, theoretically it could happen very quickly. Those things are hard to prove.
Yeah, that's what I was going to ask.
Is not cooperative. So mostly you're looking at the double requirement to be resident in one province for a year and to have been separated for 1 year. Now, that doesn't mean, I want to be clear, that doesn't mean that you can't, if you've been resident in the province, that doesn't mean that you can't start the process, even if you haven't been separated yet for a year. It's just when you submit your final step paperwork, that's the point where you need to have been separated for a year.
How long are we talking? A question of months, a year? What are we talking about in terms of in terms of how long the divorce will take?
I see. In terms of the process, months usually. So you have to serve somebody with the notice of family claim in BC. And again, the process has the potential to be different in other provinces, but in BC, you serve somebody with a notice of family claim. Once that happens, you have to wait 30 days. If they file a response, then you may need to have a court application, but that's probably not going to be a big deal. If they don't file a response, then you take default and you submit your divorce paperwork, etc. And for that, you're looking at how backed up the registry is. I would say probably about 4 months or so from the time that you submit your second step paperwork is probably.
And that's when you get a judgment or the certificate?
That's when you get your judgment that says you guys are going to be divorced in 30 or 31 days.
Wow.
And that would be for an uncontested divorce. That would be a fairly typical timeline.
Does it count as contested if the person writes back and says, screw you to the spouse initiating the divorce, but they don't actually file anything in court?
No. Because the notice of family claim tells you what you need to do if you want to contest it. And if they really want to contest it, as opposed to just flap their gums uselessly in the wind, they know what they need to do.
I think that's a good point. And I don't even know if that was fully clear to me, is that contested actually is like a legal term and a legal process. Just, I disagree with this.
You have to file a response to family claim that says no.
Yeah, that's why I was doing the desk orders, Steve, because when I was working nonprofit and I would serve the notice of claim on somebody in the Philippines, they would generally not respond at all. Or they would send a nasty letter to their spouse, but not file anything in court. And then I would be like, I'm seeking judgment. And then it would happen like super fast. And so it wasn't a big deal at all, especially for people that didn't have kids. And so, you know, and it's like, especially if you weren't seeking, you know, alimony, you weren't seeking, you know, anything other than divorce. It happened super fast. You know, it was really a very succinct resolution because so few people actually went through the process of figuring out what they needed to do to actually respond properly. So,
I mean, I will say that what you need to do to respond is right there on the notice of family planning.
For sure, but just very few people took it seriously.
It is there. You do not need to Google a thing, you know.
No.
It's laid out very simply for you if you're interested in being something other than angry.
Yeah.
I will also add, you know, sort of a note of caution that, yeah, you can just apply for a bare bones divorce. When you do that, and when you are divorced, there's some timelines that start to run. In BC, for example, you have 2 years if you're married. You have 2 years from the date of divorce to make a claim for property division. For example, if you're married, fortunately, there's no actual timeline under the Divorce Act for spousal support, though there is under the Family Law Act, and there's no timeline for child support as long as they're children of the marriage, etc. But for property division, you will be out of luck if you let 2 years elapse. And so you do, if there is any claim that you are interested in advancing, you just want to be cognizant of that.
No, that's a good point.
Yeah, this has been super, super fascinating for me. And the only thing I mean, I will definitely be in touch when I need to pursue another case that involves a messy divorce. But my only final thing is to Christian's comment about love is wicked. I would say CBSA is very, very challenging in dealing with complicated divorces. And I unfortunately feel that where there's a way to challenge the legality of a divorce, in my experience, they will take it. The legality of a marriage or the legality of divorce, which sometimes go hand in hand. So I think where there's any doubt, you need, as a lawyer or as an applicant, to be very vigilant and proactive and consider, like, one thing we haven't talked a lot about at all is whether or not you should be pursuing a sponsorship as a conjugal sponsorship or as a common law or marriage. And so we do have that option. It's a whole separate thing. But again, don't just assume if there's any complexity that you should be doing it as a spousal. That's something for you to put all the facts in front of your immigration lawyer and get some advice about it. And
if you are going to do that, you know, think about it ahead of time. And 100%. It's important to have, you know, a real thought about, okay, here might be a possible hitch. And it's very important for people to tell their lawyers what's going on, you know, all the messiness.
All the messiness. You're not doing yourself a service by keeping that information.
You know, like the person who got that second divorce in Canada, you know, I do wonder, did they tell their lawyer, their family law lawyer, that they'd had this other thing first in Pakistan, and also why, you know, what they wanted this divorce for, and, you know, that they were already married, et cetera, et cetera. You know, did they lay that messiness out on the table? Because before, I mean, and I don't know if this applies to the immigration world, but I assume that it does. But, you know, in family law, you want to know where the messy parts are before, and you want to do what you can to kind of massage, correct, and smooth those out before you're in the middle of the process.
100%.
Oh, yeah, of course.
Exactly. And also,
you don't want to be checking no criminal record, no man, and then like halfway through the process.
Because I know the immigration process takes forever and a Wednesday. And, you know, I don't know what happens, but if they reject and you have to go and fix something, and, you know, if you have to go all the way back to the beginning of the queue, I can't imagine that you're terribly happy about that.
Totally.
You know?
Exactly.
And And I mean, that, like, we're really getting a bit off topic, but like in the appeal world, you also have res judicata kicks in as to whether a marriage is real or what its primary purpose was.
But also people might see
you only get one kick at the can.
Depending on. But also people might be told you have an appeal, go for an appeal, and they might try, but then they might be told, actually, you're not a member of the family class. So then you might be $10,000 out of pocket. And then they're like, no, you have to go for judicial review. So just don't guess. It can be extremely expensive and time consuming. So,
Awesome.
Thank you so much. That was like super illuminating.